A Missouri woman is behind bars accused of hurting her children. Police say the woman allegedly intentionally fired a BB gun at her own kids while they were just standing a few feet away. According to court documents, deputies were called to the home when the children showed up to school with visible bruises. Now their mother is facing 7 felony charges. I'm Kennedi Walker, and I'll walk you through the disturbing allegations, what investigators say happened inside that home, and the charges this mother now faces. A 5-year-old boy and his 8-year-old sister are now living away from their mother. Their mom, Amy Trout, is in jail, accused of shooting both children with a BB gun. According to court documents obtained by Law&Crime, the alleged abuse came to light after a teacher at the children's elementary school saw bruises and made a hotline call. That prompted a welfare check by deputies with the Ozark County Sheriff's Office, along with the Department of Family Services. Once inside the home, the caseworker reportedly asked to speak to the children alone. That's when the 5-year-old allegedly told them, quote, "Mommy got mad," and shot them with a BB gun. He then lifted his shirt and revealed a bruise that deputies say was clearly made from a BB strike. The 8-year-old girl reportedly explained what happened, saying she and her brother had played with the BB gun when they were not supposed to and left it outside. That's what allegedly set their mother off. The kids say they were jumping on the trampoline when Trout found the gun. That's when they say she started shooting. The girl told investigators she tried to run but didn't get far. She also lifted her shirt to show where she had been hit. Deputies documented the injuries and noted the little girl pointed to where her mom had been standing, which was about 10 to 15 feet away. For context, the U.S. Consumer Product Safety Commission says BB guns can be dangerous up to 350 yards. That's 1,050 feet. These kids were reportedly struck from just 15 feet. When questioned by the DFS worker, Trout allegedly admitted she was angry the kids had played with the BB gun and said she didn't think she would actually hit them when she fired. A deputy asked to see the weapon and Trout retrieved it from the garage. The 37-year-old was then arrested and taken to the Ozark County Jail. Trout now faces 2 counts each of armed criminal action, 2nd-degree domestic assault, and 1st-degree endangering the welfare of a child, plus 1 count of child abuse or neglect. All of them are felony charges. According to investigators, once read her rights, Trout broke down, reportedly saying, quote, "I shot my babies. I'm a terrible mother." Then she allegedly asked, quote, "What type of mother would do that?" The children are now in their father's custody. Authorities say he was at work at the time of the alleged incident. And joining me to talk more about this is legal expert Josh Corman. Josh, thank you so much for coming on today. Let's just jump right in. Amy Trout is charged with 7 felonies. How much time could she be facing?
Well, I think the Class D felonies in Missouri carry 1 to 7 years, and then they've also added charges of armed criminal action, which is usually using a weapon during the course of committing a crime. In this case, it was the BB gun, and those are felonies, if I recall. I think they carry 3 to 15 years that are in addition to any other sentences that she could serve. So actually, obviously, a considerable amount of time if the judge decided that she should serve the maximum or even have to serve prison sentences on any of those. That armed criminal action actually adds a lot of time on top of a conviction, so it could be easily into the double digits.
Really? Like double digits for each charge or just all together? Like what are we thinking? 5,
It could,
10, 15?
in theory, obviously, it could get into over 10 years. If you're looking at something 1 to 7 years and then you add another 3 to 15 on top of whatever that sentence is, then it could get into over 10 years of sentence. I can't imagine that would happen in a situation like this, but it certainly is a possibility. And that's one of the things that the judge would have to inform her about when she's in court of what the potential punishment in her case could be.
Can you explain the difference between armed criminal action and domestic assault?
So domestic assault is usually just that there is some kind of assault. There's some kind of offensive touching to someone who you're either in a relationship with or a household member. So in this case, it's her kids who live in her house. So that would be a domestic assault. The armed criminal action is almost like a sentencing enhancement provision that just says if there was a weapon used during the course of the crime, then it could enhance and it adds another charge to where there's extra years that gets added on top of it. Most of the time you see these like in drive-by shootings or murder cases or aggravated robberies where a gun is used, or a carjacking and a gun is used, and it adds extra time on top of it because a gun was used. Normally you don't see these kind of things for BB guns, although, technically under the law, I guess that's something that the prosecutor decided they could charge. Whether they actually go forward with that at the end of the day would be a different issue.
And there are multiple charges for each child, correct?
Correct. And I think sometimes prosecutors do that one, or I guess in conjunction with meeting with the deputy sheriffs that were investigating the case. As you can imagine, anytime there's a allegation of a crime, there could be several different charges that could be filed. Some are more serious than others, and I think in this case, that's what they did: is they charged um, kind of different theories of the crime or different things that would fit the facts of the case. But that doesn't necessarily mean that she would be convicted or plead guilty to all of those. It may be something at the end of the day that her attorney and the prosecutor have an agreement worked out, and some charges end up getting dismissed, and she may end up pleading guilty to something.
Yeah, I was just about to ask, could these charges be elevated or even reduced later in the legal process?
Absolutely could be reduced. I'm not sure if they could be elevated based on the facts of the case that I understand and what charges the prosecutor has chose to go forward with at this point in time. But certainly the prosecutor has absolute discretion of how to handle the case. And so depending on her criminal history, maybe her cooperation, the negotiations with her attorney, and other legal issues that may come up with the case, the prosecutor could certainly make plea offers to reduce those charges if she agreed to accept a guilty plea.
Would the fact that she admitted to it after being read her rights allegedly impact the case significantly?
I think so. I guess you could look at it, both ways. One, it certainly made the prosecutor's case easier when someone confesses to a crime. But then at the same time, when you're a prosecutor and you have that discretion, they may also see this as, yeah, listen, this person made a horrible mistake, but she immediately accepted responsibility for it. She didn't try to hide anything. She was cooperative with law enforcement. She was cooperative with DFS. I would assume DFS is also going to have a case that's going to go on kind of parallel to the criminal case, where there would be services in the house, or her custody rights are going to be litigated in a different court. So all those things are going to be going on, and all those things will ultimately play out in how the prosecutor decides to resolve the case.
Yeah, I was just about to say, according to the report, she was extremely emotional. Could her emotional state during the arrest be used by the defense at all? Just maybe even, is it possible for this to even be pled down, just maybe probation?
I think so. I think that's probably a good possibility. And from reading this and from being on both sides of these kind of cases, I would think that that would be a good resolution in this. Again, this isn't a situation where she lied about it or tried to hide anything. It sounds like from what the probable cause statement says is she immediately said, "I'm so sorry. I can't believe like I did that. I didn't mean to do it. I didn't think I was going to hit him or whatever." And again, this, I think everyone would agree, this is not how you can discipline a child. This certainly is illegal. It's uncalled for. You can't behave that way. But this isn't, I guess, anywhere near the top of the kind of cases that you normally see when you think of like serious child abuse cases, and certainly some of the things that the courts and the prosecutors are going to have seen, even in this smaller county, much worse fact scenarios than what this case is.
Yeah, and like how you said, just with it being alleged child abuse, is it common for child abuse cases like this to just be resolved before trial, maybe because they don't want the kids to testify?
I think the kids testifying certainly would play a part in that. I think the kids are 5 and 8, so they're old enough to explain what happened. They're probably also old enough to at least have conversations with someone from the Child Advocacy Center, perhaps, or a counselor about their feelings and what they want. I know it made a reference that the kids were left with their father, it sounds like was in the same household. So, DCS also has their procedures to go through for dependency and neglect type cases that are not criminal. Those are civil in nature, that would decide what is appropriate, what's in the best interest of that child. And it could be that, she goes through some counseling and goes through classes, or they put services in the home, or, DCS has to monitor the family however long, and do home visits and that type of thing to make sure that the kids are safe and that they're back in a good place. And so hopefully that's something that the prosecutor and DFS and the courts all take into consideration, and hopefully can get a good outcome. Because like I said, this is something that's, it was a terrible situation. These things can't happen, but you also hate to see those things happen and someone end up going to prison or losing their kids for a decision that she made in the spur of a moment, out of it sounds like just she just made a bad decision. Her kids were playing around with a BB gun, weren't doing what they're supposed to do, and obviously the way she reacted is completely inappropriate. But hopefully, it's not the kind of thing that would send her to prison and lose custody of her kids over. And in my experience, does not rise to that level.
Are BB guns considered deadly weapons under Missouri law?
Well, I think it could be, and it could be depending on the fact scenario of a case. If you got robbed by somebody, you don't know if it's a BB gun or if it's a real gun, right? And so if someone comes up and points a gun at you and says, give me your money or give me your purse or something, you don't care if it's a BB gun or a real gun. And so for that reason, I don't think the law makes a distinction between the two. I would argue, if I were her attorney, that, well, this obviously was a BB gun. Yes, you can get injured getting shot by a BB gun, but this wasn't serious bodily injury. This isn't the kind of thing that the child is going to be in the hospital or going to have any kind of long-term medical issues with it. It was a terrible crime. But again, that's, in my opinion at least, that's not really what the Armed Criminal Action Statute is aimed to try to go against. It's tried to enhance people who use guns to shoot or guns to commit crimes. I would argue not necessarily a BB gun in this situation.
Right. So it could potentially change the legal outcome. The defense saying, like, potentially, could that be an argument? Hey, I wasn't trying to hurt my kids. I was just playing around. Could that work?
Or playing around, or like I said, she admitted, like, I made a bad decision. I didn't shoot him on purpose. Yeah, I fired the shot, fired the BB gun, but I didn't actually think I was going to hit them. Whether that's a good excuse or not, again, it's certainly, it just doesn't rise to the level of, sadly, what we see a lot of times in just serious and tragic child abuse cases. This seems more like a one-off type of a thing. And again, I don't know her history or if she's had any dealings with DFS before or anything but it didn't sound like that just from reading the probable cause statement.
Does the distance from which the children were shot factor into how prosecutors built their case? The kids, reportedly said that they were shot from 5 to 10 feet away.
I mean, I think so. I mean, it sounds like they weren't running away. It sounds like it was something that happened quickly. And I don't really know all the facts of it, or whether, sounds like she was a good enough shot to hit him in the stomach or something. But she was just like, I didn't really actually think I would hit anything. But again, the argument can also be made, well, why would you fire a shot if you weren't trying to hit something? What would be the point of doing that? I guess thankfully we can just say this wasn't a real gun. There wasn't any serious bodily injury to the children, and hopefully, this is something that this family, through the court system, can try to get this worked out and move on with their life.
Could this be considered aggravated assault depending on the injuries?
Every state has different laws. So in some states, I think you probably could charge it as an aggravated assault. I think in Missouri, they have charged the kind of the felonies that they think that they could prove, or the felonies that would be appropriate. There certainly could have been misdemeanor charges that they also filed, and that those are things that could potentially be amended down to it at some point in time. Like I said, anytime you have a fact scenario, there are several different statutes that the prosecutor would be able to use, and they have all the discretion and all the authority to decide how it is that they want to handle that case, however serious they want to take the case, or how they want to work it out to give someone some kind of a benefit or a bargain.
How does a child welfare agency typically proceed after discovering alleged abuse like this?
So I think anytime there is a allegation of child abuse, there are kind of two investigations that happen. It sounds like in this case, the school was notified, or the school learned from the two kids that they had been shot. They then made a call or a hotline to the Department of Family Services. Family Services then is responsible for doing an investigation, and then law enforcement is also responsible for doing their own investigation. Sometimes those two investigations combine, but they are separate. The DFS investigation, like I said, will be in front of, it's civil in nature. It's in front of potentially a different judge. There's not a prosecutor. There'll be an attorney from Department of Family Services, and that will be separate than whatever happens in the criminal part of the courthouse. In this case, it sounds like they did combine them, and that's something that the defense attorney may be bringing up in this, because from reading the probable cause, it sounds like they went to the house with the DFS worker, but then instead of Mirandizing her and giving her rights, they let the DFS worker ask all the questions, and then based on what was said, they ended up arresting her. And so I think that that is something that a defense attorney is probably going to try to capitalize on, whether that was appropriate and whether they have violated her rights, kind of in the manner that they tried to question her. There is a statement in the probable cause saying that the deputies didn't ask any guilt-seeking questions, which it sounds to me like they're acknowledging the fact that they understand that there are Miranda issues there. There was a Supreme Court case about 20 years ago in Missouri versus Siebert, that kind of got into that issue of where you question a suspect and don't Mirandize them, get the information that you want, and then give them their Miranda rights. And at that point in time, they've already told you whatever happened, and it's just kind of a continuation on. So I think in the spirit of Siebert, that very well could be something that the defense attorney either tries to argue or tries to use in negotiating with the prosecutor.
Right. And it's interesting that you brought that up, exactly, because, we're just reading the documents. They do ask her, well, where is the BB gun? Stuff like
Right,
that. Is that kind of
right.
her admitting to it? Could that be considered that?
Well, I think so. I mean, that certainly would be a guilt-seeking question in my mind. Like, where's the alleged weapon that was used in this crime? So, the deputy putting in there, we didn't ask any guilt-seeking questions. I would probably take issue with that, whether they did or not. And again, whether it was intentional or not, kind of using the DFS worker to ask those questions while they just stood by and were part of it, I think that could certainly be an issue to be litigated in court if this is not something that the prosecutor is willing to try to work out a deal on.
Is she likely to lose her parental rights? And if so, just explain how that would work if mom and dad both live together or they're in the same home with the kids.
Right. I would not think that she would lose her parental rights. There's kind of different levels. Dependency and neglect cases, like I said, go through court, and a judge has to make a decision of what is in the best interest of the child. There might be a guardian ad litem that's appointed to also advocate for the child. DFS attorneys are going to be involved to advocate for what's in the best interest. Certainly, the father is going to have his say. The kids may have a chance to say what they think should happen. But then the next step up to terminate someone's parental rights, that is a huge step that's well beyond kind of what a dependency and neglect case is. We refer to that as being the civil death penalty. And I just can't imagine that this case is the kind that would end in a termination of parental rights type proceeding.
If she has no criminal record, does that help her case?
100%. So in Missouri, there are certain statutes, or the way the law is she could be put on probation. She could have what's called an SIS, or a suspended imposition of sentence, so that it is actually not a conviction against her, depending on if the prosecutor and the defense attorney can come to an agreement. There are also some of the statutes that she's charged with, though, are not eligible for probation. So that would be a consideration for both sides to, if they have a plea worked out, to make sure that it's one of those under the statute that would not forbid her from being on probation. Or I think sometimes you can get probation, but you would have to serve a year in jail before you'd be eligible for the probation. So I'm sure those are all things that are going to be considered by both sides as this case goes forward.
Now let's talk about the children. I have to bring them up. I'm sure that this is a traumatizing experience, not just being, allegedly shot by a BB gun, shot with BB gun, but also just
Right.
seeing their mom get arrested, knowing that they're spending, days upon days without their mom, not knowing if or when she's going to get out. Are there legal services in place to ensure that the children receive counseling, receive some type of help?
Absolutely. So Department of Family Services has counselors. The Child Advocacy Center provides counseling in cases of child abuse or child sexual abuse. The prosecutor's office also has liaisons for counseling to try to set that up. And like I said, I would imagine that there would be a guardian ad litem appointed. That's like an independent attorney who is just the attorney to represent the best interests of the kids. And that person would also be advocating in court for what should happen, what the kids want, without them having to testify or say anything. And I would think that counseling would be one of those things that the family court would also be trying to set up.
Well, great. Thank you so much for coming on. This is a story that we will definitely be following. Thank you, Josh.
Absolutely. Thanks for having me.
Amy Trout is being held without bond. She is set to appear in court on April 29th. For Law and Crime, I'm Kennedi Walker.